Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about workplace drug and alcohol testing. Cases that should have gone to the Supreme Court of Canada, but didn't. The Canadian Nuclear Safety Commission, a government-run organization, put in place a requirement for anybody starting employment and in employment in their organization to have random drug and alcohol testing, as well as pre-employment drug and alcohol testing. This was mandatory for all individuals, regardless of whether there was a reason to suspect that they had been involved in some sort of an addictions or drug or alcohol related issue that compromised their safety at work. In Canadian employment law, there are strict standards for when drug and alcohol testing can be performed randomly. But with private companies, there is also a lot more power than there is when it comes to government organizations. And because this was a government organization, it engaged this question under the charter of whether or not this constituted an unreasonable search and seizure, especially because employees of this organization could then be subject to investigation by a regulatory body and essentially charged with offenses based potentially on the results of those tests in combination with some other factors. This raised the question of whether or not the government had effectively authorized an unreasonable search and seizure by requiring suspicionless and warrantless testing of individuals without any foundation to do so other than that they worked at this particular place. Unfortunately, the workers lost this argument, and the court determined that it was appropriate for the company to be doing this and that it didn't constitute an unreasonable search and seizure. But this case does raise these very important issues about the extent to which government can start to engage in infringements on the privacy rights of employees when it has potentially no basis to do so. And while there may be reasons in relation to nuclear safety that drug and alcohol testing would be warranted, the degree to which these intrusions are allowed in this case leaves the door open for further intrusions by government in other aspects of employment and other cases where employees may challenge this as a violation of their charter rights. They may not be successful because of this precedent. The Supreme Court of Canada had the opportunity here to rein in what could potentially be an example of government overreach. And unfortunately, they didn't take this opportunity. This case is a significant case because the ways in which your Section 8 rights, your charter protected rights, are engaged as an employee of the federal government or of a provincial government is something that has very rarely been considered by our courts. And it would be really important for the Supreme Court of Canada to delve into this and provide more guidance so that the government knows what they can and can't do with very clear boundaries and limits on the scope of their authority. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazenville Creative for putting together these videos. Please like, subscribe, and share with your friends.